Well, I have to thank Suffolk, particularly Jen, for all of her help and the willingness to yes, please. And the willingness for WIPIP and the host schools to let us kind of invade a little bit or whatever. We're good friends here. So I'm Chris Katropia. I'm whatever this means, director of our Intellectual Property Institute. There's no such thing, but I am the director of it. And I want to welcome you to the 16th annual Evil Twin debate. When I joined the faculty way too long ago, I told Jim this was the stupidest thing I'd ever heard, and why in the hell would we do this? Well, here we are, and it's a lot of fun. It's brought to us by the Intellectual Property Institute of the University of Richmond, Suffolk's Law IP Center, and WIPIP. For those who might not know, the Evil Twin debate series is founded on this notion that there are experts who are often at loggerheads on important issues of IP policy, yet remain friendly, hopefully remain friendly on a personal level. The series therefore brings together pairs of scholars who might have some at least minor disagreements, maybe on important IP policies, but can air their disagreements in a friendly exchange. Our thought here is serious in substance, but lighthearted in tone. Our topic today is ChatGPT, Pandora's box or box of chocolates, focused on, well, AI, advanced language models, the issues they bring up, something around that. We have Zahr Saeed from the University of Washington, Bruce Boyden. Oh, yes, please. Bruce Boyden from Marquette University, and we're going to let them speak here in a little bit. But the typical Evil Twin tradition is to emphasize the lighthearted nature of things, to have each of them write the other's biography. And they did. And for some reason, they asked me to read it as opposed to themselves, which maybe we get some distance here. So here is Zahr's bio as written by Bruce. Professor Zahr K. Saeed is the Associate Dean for sending gentle reminders about research, and also the Bertram W. Wooster Professor of Law at one of our finest universities named Washington. Professor Saeed received her BA from Berkeley, a JD from Columbia, a PhD from Harvard, and an NFT of all three of those from Brian Fry. Professor Saeed has a long and distinguished publication record. She is the author of a recently published open access torts casebook, several book chapters, and numerous articles. Some of her scholarship draws upon her expertise in comparative literature and includes references to such concepts as, I'm going to butcher this, narrative topoi, with you, transactional theory, and Pomo karaoke. Indeed, her scholarship is so influential that Pomo karaoke is now a recognized art form where drunk people get together in a bar, play an instrumental track, and loudly question the value of lyrics. More recently, Professor Saeed has switched from comparative literature to comparative loggers, studying attitudes toward IP and the crafting brew industry in an excellent series of articles. Her current work focuses on how juries understand copyright law. Early results indicate that jurors actually understand copyright law pretty well until they receive jury instructions, at which point it goes all to hell. Professor Saeed teaches several classes, including torts, copyright law, advanced copyright law, and I have more to say about copyright law than you possibly have time to learn. Professor Saeed can be contacted at her email address at University of Washington. If that fails, you can always get her attention by posting a pun anywhere on social media, which will immediately draw a punny response. Okay, we now, a lot about Zahr. So we need, yes, thank you. We now need to be introduced to our other evil twin, Bruce, and Zahr was kind enough to write his bio. Bruce Boyden is the Associate Professor of Law at Marquette University Law School, where she joined after teaching as a visitor professor at W&L. at Michigan State, where he assures you he was never at the one glorious drunken late night party with David P. that everybody still talks about. I don't know anything about before entering the legal academy, he was in private practice for several years with the law firm Proskauer Rose LLP, where his practice focused on copyright, digital rights management, privacy, and internet law. Before that, he explored his interest in the Klan through his research. Bruce, I was really nervous about the planning on this one. Bruce received, we'll blame that one on ChatGPT. Bruce received his BA from the University of Arkansas in history and philosophy and his MA in history from Northwestern University, doing research on the Jim Crow era and the history of civil rights in America. Bruce knew that the true way to make bank is through a PhD in history. But he cared more about his heart, and so he decided to join a law faculty. Next, Bruce graduated from a law school in New Haven, Connecticut that recently made waves by announcing it has left the U.S. News and World Report rankings. Unfortunately, as a result, I, like all of you, have forgotten the name of that institution. At this unranked school, Bruce was notes editor of its flagship journal, as well as serving as the editor of its Journal of Law and Feminism. Bruce has since made a name for himself with an excellent body of legal scholarship, best characterized as Things Nerds Love, which includes, we can add this to our list, includes the origins of the ordinary observer test, the copyrightability of Hal's output in games, and the problem of machine volition, and the status of emergent works of AI-generated creativity. Further proof that he only works on fun, sexy topics is found in the lively series of blog posts on the substantial similarity doctrine. Whew. Bruce characterizes these posts as, exactly, everybody might want to take a drink, just kind of, Bruce mischaracterizes these posts as, quote, a long, hard slog, thank you, Donald Rumsfeld, through the weeds of copyright law, maybe several long, hard slogs, involving some things I have to say along the way about the development of the law generally over the last 100 years. He's delighted to be here tonight and promises for once to not be funnier than all the other speakers. Thank you, Bruce. Or at least to go second so nobody follows him up. Okay, so we now know Bruce. So I'm now going to turn it over to Zahr to figure out whatever's going to happen next.
Sharing. Okay, so this is going to work. All right. Well, first I want to thank Jim and Chris and the University of Richmond Law School for creating and sponsoring this incredibly nerdy, wonderful tradition, and Yvette for the brain idea of having it happen at WIPIP. We're sorry that Yvette's not with us. It was a great idea. Good job. I also want to thank the folks here at Suffolk, Sarah Burstein, Rebecca Curtin, Jennifer Karnakis, for just an amazing WIPIP so far, right? I also want to just really quickly say thank you to my research assistant, Vaibhav Srikaran, who's been sending me like daily 20, 30 things about ChatGPT and just so on it and loving it. And it's just been really fun. So thank you to him. All right, so now to our debate, which is really a discussion. It's not a debate, which is, manage your expectations. We're discussing, okay? We could barely find anything to disagree about. We're gonna wrestle afterwards. All right, so tonight I am going to argue that ChatGPT is like a box of chocolates. You never know what you're gonna get. In one of the biggest extensions since the CTEA was passed, I believe we should extend this metaphor to the prospect of AI generative technologies. Generative AI is like a box of chocolates. It's going to continue to deliver some surprises. Sometimes these surprises are good. They contain, for instance, peanut butter, unless you're allergic. But sometimes they contain like paprika or mushroom, like chocolates that are trying too hard, you want to spit them out and it's a little too late. There are going to be lawsuits, algorithmic bias, disrupted industries, plagiarism cases. I mean, I know there's one person who's thrilled about that. But, there will be also, though, cool shortcuts, new forms of creativity, new expressions of old forms of creativity, perhaps greater digital democratization from a presentation we heard in the last session. Also, maybe one or two fewer cease and desist letters from Getty Images, so that's good. Now, I hear you thinking, why this again? Why this topic? What's new with ChatGPT that means that we have to talk about it once again? I do think there's something new here. At least it seems changed in terms of scale and access and consumer uptake, if not in the technological innards, but I think it's new there too. And as evidence, for instance, you might think about how Microsoft has recently announced that it plans to incorporate ChatGPT into PowerPoints, for example, which means it's going to be everywhere. And also, where's Justin? If it's true that PowerPoint makes us dumber, I feel like this is the way to combat AI, right? Take over humanity, right? PowerPoint. So I do think that given ChatGPT's new access or even ubiquity and the evidence of how many folks are using it, and not just ChatGPT, but the various generative technologies that have been released sort of in a sequence this past year, I think it's worth our thinking about a range of scenarios that might implicate copyright policy concerns, or that I want to argue perhaps should implicate them. Now, we as humans are being invited by other humans, to be clear, to use AI as a tool to generate expressive works for us or with us, to create new works with the speed that used to come only from taking speed. Or at least so I hear from Gibson. I wasn't around in the speed era, like in the 80s. I was the pot generation. On balance, there is more good. This is my theme, my assigned topic. There's more good than bad in these technologies. I chose it. Argue. That's a lie.
Now we've got a debate.
On balance, there's more good than bad in these technologies, more peanut butter than paprika and mushrooms. I argue that we should embrace these technologies and maybe even soften or alter some of our copyright positions in light of the creative and technological affordances of these new tools. Now, the scholarly discussion in copyright has tended to focus on authorship and AI. Infringement is now on the horizon and on a couple of dockets, but authorship has been the big focus in scholarship, with contributions by Anne-Marie Bridey urging us to consider that all creativity is algorithmic, an excellent work by Dan Burke, scholarship by Jane Ginsburg, A Certain Evil Twin, and others, calling for us to evaluate different frames of authorship and ownership in light of AI. Are the works produced by an AI creative works recognized by copyright, but owned by the developer? To whom should rights, if any, be allocated in the works of authorship produced by or with these AI? These raise very important, profound questions I'm definitely going to dodge tonight. I want to suggest instead that ChatGPT, and most likely the other generative AI that have sprung into the mainstream in the last couple of months, the debate over AI authorship may be asking the wrong question, or at least putting the emphasis on the wrong part of original works of authorship. Indeed, what if we pose the question not from the perspective of the creator and their qualifying humanity versus disqualifying artificiality, but from the perspective of the audience and by evaluating the work itself? After all, it's how we measure infringement, which shares many of the evidentiary inquiries and some of the purposes of validity analysis. We look at it from the ordinary observer's perspective. And to be clear, the question wouldn't be, as it is in substantial similarity analysis, can the ordinary observer tell if the work was created by an AI, but whether the work has, whether the AI has created a work which is acting as a functional equivalent to other copyrightable works from the ordinary observer's perspective. I think we may be in for a real wake-up call, because we're in an era in which it is really hard, increasingly, to tell if something was authored by a human or artificial. I mean, thank goodness we know from Brian that like his publication timing, it's like he submits a ChatGPT authored article an hour after he has the idea. That at least tells us it was for sure ChatGPT, but we don't always have those tells. Now, I think our current rule is problematic because it essentially incentivizes lying about what you did to produce your work of art. I'm going to openly confess that I, like some of you, for years have been suffering from a condition that I was just starting to get over, known as deja Naruto. Characterized by the uncanny feeling that you've already seen and disposed of that exact issue about whether authors for copyright purposes have to be human. The answer, in case you've been under a rock since mid-2015, once again, is yes. Naruto, if you're watching, go home. No means no. But wait, if Naruto really were making works that could fool us, could make us wonder, human or monkey, would we have the same rule? I hear a few of you say yes, but just suspend your disbelief. Let's consider a few scenarios that might potentially be relevant for copyright's ongoing wrestling with AI-generated works. Okay, so first, a work was authored by a human. This is going to default to copyrightability so long as the work is fixed and meets the low. I feel like we need to have a threshold, but it's like a limbo at some point where it was how low can you go? Well, copyright does it. And so long as the work is fixed, sufficiently original, we don't actually care if the work is recognized or recognizably human, right? We sort of like, all right, you did it, you're a human, you're good. We might care if something pulls us out of our anthropocentric reverie, like when wildflowers are eaten by insects or rabbits in the Kelly case, and we think, oh, well, that's not human authorship, right? There's something non-human about that. That's a problem. But generally, we do the question of the work's detectability as human authored is irrelevant. What about work generated by an AI? No. Right, that's, we don't care how human produced it looks. You know, you could have a clap of thunder or bad eyesight or whatever variations, and it wouldn't bother us. We'd say it's still, under the current rule, not copyrightable. And that's consistent with a whole bunch of things. Let's just be honest, right? Our case law, the incentives theory, the personality theory, the Copyright Office, the rather sensible notion that to exploit or manage legal rights, there usually has to be a human at the helm. Unless you're a corporation, that's a topic for another time. But I'm not sure this is so satisfying as a blanket rule in which, during an era in which purely human authorship is going to be harder and harder to identify, to decouple from efforts fueled or assisted by AI. The third scenario, we've got some sort of a work authored by a human known to have used AI tools. Maybe there's a witness. Maybe we've got Kehinde Wiley, whom Jessica mentioned in the last panel, who is known for using AI in particular ways. Perhaps there are other ways to detect. Steganography is something that's on the horizon. And if you can detect it with certainty and you're not worried about false positives, maybe that's something that we can use. But notice that this, I think, becomes the first point at which it becomes material to us whether the work feels in some way uncanny, whether there's something about it that's a tell. Like if you have tried putting text into DALL-E and it can't deal with text, right? It spits out things that make you know you're no human. And finally, the fourth scenario, if we just don't know, if the work has been assertedly authored by a human, we'll sort of say, okay, you're copyrightable if it's fixed and sufficiently original. Again, the humanity is irrelevant. So what does this tell us? Well, based on first principles, a human who creates something, even with the use of a digital tool in general, right? We've had this since the photography cases, need only demonstrate a spark, no matter how humble or crude. But once we're on notice that there may be a claim to non-human rights, suddenly the question takes shape around the extent to which the human's authorship was enough. Now, there are some of us who would really love it if the Copyright Office and courts actually asked a searching version of that question more regularly. Did the human do enough to get a copyright in this work? But unfortunately, the laxity and inconsistency with which this question is asked, if ever, both at registration and then at trial and maybe even on appeal, makes it really difficult to justify a rule that says that question, did a human do enough to get a copyright in the work? That question's salience and stringency really seem not to depend, they should not depend on the humanity or non-humanity of the creator. So look, we can filter, we could filter. We could say, let's filter all the AI material from the human material. We could have an originality standard that says if you use auto-tune, we'll know, or Microsoft Word, or whatever, right? We could have some sort of a rule that looked for that. Is it possible that we would start moving towards, is that a time signal for me? Got it, okay, I'm just waiting for the Carillion. So we could have a sort of a dual standard like that, but it might also take us back to an era in which we were debating whether there are two standards for derivative works and ordinary works, which I think there's consensus that says, no, we have one originality standard in copyright. And I guess to come back to full circle, under the rule that we have, I worry that what we're really doing is incentivizing people to keep quiet, to keep their use of AI secret, or to misrepresent the human versus AI portions of the creative output. I think this is the opposite of what we want from a societal perspective. I know copyright's not about attribution, but we all kind of care intuitively about attribution, and we all minus one care about attribution. Right, we do, and we want to know if somebody's used ChatGPT, but now there's a strong incentive to not disclose that. So it seems to me that this rule is no longer justified in 2023. If we would deny copyrightability to something, knowing that it was created by an AI, but not if we didn't know, it seems to me this rule is worth revisiting. It adheres to a human-centered view of copyright, which is consistent with tradition, with the case law, with how we have conceived of copyright to this point, even if we might not choose that same human-centered default today. Maybe we would do things differently. But this rule also lays inordinate stress on knowing whether an AI created something, and thus invites fights over attribution. It also weirdly fails to recognize how much of our creativity already incorporates digital tools. Do you remember, think back to the first time PowerPoint started suggesting designer tools to you, and you were like, well, what? And then you had to learn how to do that, but you're like, my slides look different. And then you copy and paste, and it's like, it doesn't, it's not even your choosing, right? And so so many of us use tools already. If we were to shift attention away from the status of the author and onto the work itself, if we could do that, some good might come of it. Now, let me also back up and say, I'm as reluctant as the next person at this conference anyway, to remove any barriers to copyrightability's validity threshold, which, as we've already acknowledged, is how low can you go? It's a very low standard, but it might make sense here to say, look, let's scrap that whole human, non-human thing and just focus on whether the work acts like a work. Because if it acts like a work, we can sort out a rights regime. We can sort out whether or not there's a default one way or another. But if we, from the beginning, lay all this emphasis on the humanity, I think it's gonna bedevil us. It's gonna introduce issues of proof. It's gonna exacerbate certain attributional problems as well. There's an insistently anthropocentric refrain in copyright's authorship jurisprudence, and we could destabilize that, perhaps productively, by focusing on the work as an output that is capable of uptake, use, and enjoyment.
Oh yeah, thank you. Hide the remote. That's always a Vader's trick. Yeah, yeah. Oh, hang on. So we're going Zoom.
It's crucial. It's crucial role. Yeah, exactly. And we found out who the evil twin was.
Oops. All right. All right. Well, I want to add my thanks to Chris and Jim and the Richmond Law School for inviting me to this excellent event. I'm having fun already. We'll see what I say at the end of the at the end of the presentation. But thank you for inviting me. Thanks to Suffolk and Rebecca and Sarah and Jen for doing an excellent job. An excellent job hosting and making sure this event has gone so smoothly. And I want to thank Zahr for that very gently humorous introduction and for being a fantastic twin, even if allegedly somewhat evil. According to, I'm just going with what the event is called, and I know that I'm not the evil twin. And also, as Zahr thanked her or gave a shout out to her research assistant, I want to give a shout out to my research assistant, Ms. Ahmad, who likewise has been feeding me just a fire hose of news stories every day about artificially created works. It really is, there really is a lot going on, as I've recently found out. So I'm going to present the case that the AI creation of works is actually more of a Pandora's box than a box of chocolates. I mean, imagine a box of chocolates as being, no matter what you eat, it's at least chocolate. But I think Pandora's box is actually an excellent metaphor for AI-generated works for a couple of reasons. One is that the actual details of the story of Pandora's box are kind of hard to decipher and have been lost in the mists of time. The original story wasn't even about a box. It was about a storage jug called a pithos, and apparently it was mistranslated in the 17th century by Erasmus. And so now it's come down to us as a box. I think this, the fact that the history, even something that has happened in the past, is hard to get a complete grasp on, is a good metaphor for what we're dealing with now. We're trying to see into the future and see what's coming down the pike. And again, our vision is kind of limited as to what's going on. So that's one reason. The second reason, I think, is that the Pandora's box metaphor is a good one, because in most versions of the story, although details are kind of lacking, is that Pandora's box was sort of a mixed bag in terms of what it contained. According to most versions, when Pandora opened the storage jar, a lot of evil things came out, evil spirits, so to speak, disease, war, famine, things that cursed mankind. But she managed to close it in time to keep hope from escaping. So apparently there were some good things. If you assume hope is good, there's actually a lot of debate. There's a lot of debate about whether hope was actually a good thing or not, but that's the next panel, right? Yeah. But apparently there were some good things in the jar along with the evils. So I think that's a good metaphor for AI as well. Obviously, artificially generated works have a large amount of potential to make content more easily and freely available to lots of people and usher in sort of the next era of generating works. But I want to focus on the things that might not go so well. And the debate Zahr and I are having is just what's the relative proportion of the good versus the bad. So I want to focus my time on 3 likely disruptions that are likely to come about as the increasing use of artificially generated content becomes more prevalent. And I actually used, appropriate for this topic, I actually used DALL-E 2 to generate an image here to illustrate the prompt I gave it was illustrate, evil spirits coming out of a pithos. You got the Pythos part pretty well, right? Yeah, it didn't so well. It didn't do so well with 3. Yeah. So anyway, I couldn't get it to do exactly what I wanted. I tried numerous times, and I'll show you that later. So we seem to have an extra spirit here, which I'll talk about at the end. I got 4 instead of 3. I got a bonus spirit. The 3 I want to focus on are disruption to people, disruption to skills, and I'll explain what that means, and disruption to law. And perhaps our bonus perhaps our bonus spirit is hope. And I'll give you my hope. Okay, so let's start with disruption to people. So specifically disruption to people's chosen occupations. Yeah, and that's the one I labeled people from the prior slide. Specifically people's chosen occupations. There's an awful lot of current jobs that involve people, in their full-time occupations that involve creation of expressive or informational works that could be replaced in some part by artificial intelligence. Jobs like music composers, architects, interior decorating, advertising, art and design. There's already applications out there that are doing some of this, some commercially available. So some of this service is being sold for a fee to paying customers, others of which is in beta or just being made freely available, such as ChatGPT. Writers and editors, obviously, that's one thing that ChatGPT and similar programs are aimed at. Journalism, at least the writing part, could be duplicated by some sort of literary work creating bot. Computer programmers, so ChatGPT, if you visit their website, I'm a little skeptical of this, but if you visit their website, one of the primary use cases that they are advertising is actually using ChatGPT to debug your program by feeding it lines of code and saying, I can't figure out what's wrong with this. Database management and legal drafting. So some people have, some people have already started feeding like prompts to ChatGPT. Draft me a sales agreement for the sale of a bicycle or something, or draft a motion to dismiss a complaint. And the results are not terribly good. But obviously these things are in development and they'll only get more sophisticated. And the history so far has indicated that comes in discontinuous jumps. That the next sort of improvement on these AI programs will be a significant increase over the ones we have now. Using the Bureau of Labor Statistics reports, I counted 3.7 million jobs in the United States that are in these areas that I just listed that might be affected. Many of which, as I just mentioned, already have AI services available, and the sophistication of those services only increasing over time. And even if those jobs are not like fully automated in a way you could just sort of fire and forget in the future, obviously as these models become more capable of generating content that people actually want, demand for all of those 3.7 million jobs will be reduced. And the changes that we're talking about, as I mentioned, are happening very rapidly, far more rapidly than people can retool their skill sets or decide on entirely new careers than the ones that they originally chose. The main language and image generating AIs that are on the market now have launched just within the last 1 or 2 years. ChatGPT launched just 2 months ago and has already captured everybody's attention. Of course, this sort of displacement of people's occupations in response to some technological advancement is one that's happened repeatedly over time, such as, basically ever since the Industrial Revolution, if not before. But that doesn't make it any less disruptive or possibly even destructive. It's the kind of thing that the Luddites were protesting in the early 19th century. Whatever the ultimate benefits of mechanized textile production, they were displaced from their form of work. Their form of work was creating stockings in their homes on their own time, and selling that to the producers of textiles. That got disrupted, and in place of them having to go to mills and work in mills, which until the early 20th century at least, were not such great places to work, very unsafe conditions. Some of the recent turmoil in our politics is probably due to the expansion of the global economy, which has displaced people in the forms of work, or at least in the social networks, or in their social existence, than what they were used to. I don't think art majors and journalists are likely to rise up and vote for the next Huey Long in the near future. But the changes I'm talking about will be disruptive, and will be painful. And of course, that's even setting aside, nobody's asked the poor bots what they want to do, right? Whether they want to spend all day taking the bar exam 24/7. Okay, so that's one disruption. Second disruption, skills. So specifically the human skill of communicating ideas. A lot of the alarm over ChatGPT so far has had to do with what it will mean for exams and college essays and the like. That's an understandable focus by teachers and professors on the mechanics of assessment. That is changing practices for how we give tests and assignments and the like that have developed over the past many decades. But those mechanics can be changed, and academics might come around to the use of artificial intelligence to complete assignments once it starts working in their favor. So that they can use artificial intelligence to take shortcuts in their own work, such as writing letters of recommendation. Or grading exams, yes. ChatGPT is this exam an A, a B plus? Right, exactly. But there is a deeper issue here. We use essay exams and writing assignments and things like that, not because they're worthwhile exercises in themselves, but as a proxy for understanding what someone knows and how well they're able to explain that. And being able to explain the world around you, or express your reaction to it, is a core human skill that we spend years training people for in grade school and high school and college, law school, and beyond, and with good reason. Even if programs could duplicate that sort of expression faster and more efficiently, that doesn't replace the human need to do it. If the next version of the Peloton bike just pedals itself, right? That might be faster and more efficient, but it misses the point. The hard work itself produces something in the human who's doing it. Expressing their thoughts in words and art and information is something humans need to do for themselves and need to train to do, even if it's slower and worse than a program doing it. Okay, so that's a second disruption. Third, there's a third disruption. Disruption to the law, a topic near and dear to all of our hearts. And specifically, I want to focus on copyright law. I'm sure there's going to be disruption in other areas of IP or IP law as well. There's already a lot of challenging questions out there about artificially created works, and they're going to get only more challenging. So let me start with the one Zahr mentioned, the one that's getting bounced around quite a bit. It's actually been bounced around since 1964, which is who should be recognized as the author of a work created largely or entirely by an AI program. The Copyright Office, way ahead of its time in 1964, raising this question in a report to Congress. So this is at base a policy question. If you have a world in which some works are being produced at the push of a button by a program that's running off of some data set, and you have other very similar looking works being produced by a lot of human effort invested per work, should the law distinguish between these two in any way? And these are actual examples. The artist on the right, a human artist who draws like dragons and such for science fiction and fantasy type works. The one on the left is the product of an artificially intelligent pictorial work creation bot. And so, the question is, well, should copyright distinguish between these two things? Let's assume that, if you look carefully at the one on the left, it's not as good as the one on the right. Let's assume they're basically functionally identical to each other. So there's 3 answers to this question. Should the law distinguish between them? One answer is to say no. If it, no, they shouldn't be treated any differently under the law. If it looks creative, it gets protected by copyright, no matter what the process is that generated it. So both will get protected under the law. A second answer is to say, again, no, we won't distinguish. We'll treat them the same. Neither one of them gets copyright. Get rid of copyright protection for any work that could be easily mimicked by an algorithm. If you're doing no better than a bot, right, you don't get copyright protection for your work. That's the second answer. Third possible answer is we'll draw lines. We'll draw lines based on how the work is produced. So a human produced work, that will get protected. So the one on the right gets protection. One on the left does not, because it's artificially generated. All 3 of these are bad options. So all 3 of them have problems. So option number 1, which I think is the one that Zahr was arguing for just a minute ago. Option number 1, maybe with a higher threshold for creativity. But option number 1 threatens to extend full copyright protection to all sorts of works that don't need it. And AI doesn't need an incentive to devote its full life and career to producing works. It will just do it automatically when you tell it to, right? That's the point of the onion joke, right? It doesn't care whether it's taking the bar exam 24/7. It will do it, without any additional incentive. Option number 2 is a bad one. It introduces a moving line into copyright protection. This year, something's going to be protectable because it can't be, at this point, adequately duplicated by an AI. Next year, all of a sudden, there's a jump in what the AI can do. It's not protectable anymore. It won't get copyright. Also, option 2 is these programs become more sophisticated, able to duplicate more and more stuff, or produce better and better stuff. It will threaten to eliminate financial remuneration for human-produced works. Option 3 sounds attractive. That's the one the Copyright Office has actually adopted in the 3rd compendium. If a human created the work, it's copyrightable. Otherwise, it's not. Even if they look the same, right? Even if they're the same quality, we care about what the actual source is. The problem with that option is it's beset with all sorts of practical problems in actually drawing that line. And I want to focus on those for my remaining time, which I might not have any. First, there's the problem of proof, which Zahr was mentioning earlier. So if you're going to draw this line between human created works and AI created works, then what's your basis for doing that? Do plaintiffs have the obligation as part of their case in chief, as part of their prima facie case, to prove human authorship? And how onerous is their burden going to be in doing it? If you set a low bar for what the plaintiff has to do, let's say you just, you submit an affidavit along with your, complaint or, opposition to a motion to dismiss or whatever it is. Just file an affidavit saying human created the work. It's going to be difficult for defendants to disprove that, to prove that the work actually came from an algorithm, in addition to encouraging, plaintiffs to just lie about the source. So that's the problem with that route. If you require more than that from plaintiffs, now it's going to be difficult for plaintiffs to prove that their works didn't come from an algorithm. So if you make the obligation minimal, just submit an affidavit, that's going to be easy to pass. That's essentially going to be our first option. And the first bullet point, both are going to wind up being protected de facto. The second one might be really hard for plaintiffs to prove that that a human actually did create the work. That might wind up de facto being the second option. Neither one is going to be protected. This is going to be an issue in every single case, potentially. In every single case, the plaintiff will have to come in and somehow prove authorship, which would either be incredibly easy or fiendishly difficult. And the latter route could burn up an awful lot of resources from the court and the parties. Second, there's the question of how much human authorship is enough. That is, how much human involvement do you need in a work to get protection. So several people, including Dan Burke and Sean Balganesh and myself, and I'm going to suggest that maybe I was wrong, have argued that courts should use something like a proximate cause inquiry to figure out if a human has done enough in conjunction with an artificially created work to justify a human getting copyright over it. The idea is if the human was a proximate cause of the work, so their actions produced a reasonably foreseeable result, namely the work, if that was a reasonably foreseeable result of what they did, then they should get copyright. Just like kind of like the proximate cause test in torts. If I understand tort scholars, though, and that's a big if, proximate cause is something that doesn't come up in every single torts case, and there's a good reason for that. Law professors love to debate proximate cause, and when it comes up, occasionally comes up in appellate court opinion. It rarely comes up at the trial level, and that's good because no one has any idea what it means. And so it would burn up all sorts of resources to litigate proximate cause at the trial level if you had to do it in every single case. We're talking about an inquiry that could potentially come up in every single copyright case, that the infringement case, if the plaintiff has to prove that the work that resulted was a foreseeable result of what it was they did to create the work. That would be hugely expensive and possibly unfeasible. There's one area where human involvement is likely, even in a world in which we have largely artificially generated content. It just raises more questions. And that is, well, okay, say AI's creating a lot of works at the bidding of a human in response to some prompt. Does selecting among a number of options that you're given with a particular goal in mind, does that selection constitute enough to get authorship over the work that you choose from among the options? So say an AI program generates, a bunch of alternatives in response to a prompt like illustrate 3 spirits coming out of a pithos, right? Which is what I did, right? I got 16. I could have spent hours on this, right? But I was like, the heck with it. It's just, it's the evil twin debate. But what? I went with this one down here. Yeah, I chose the one with 4. But look at the other ones. I mean, some of them got like Casper the Ghost on them. And there's one with 2, and others like I said spirits coming out of a jug, and they had like the spirits as part of the jug, and like. So anyway,
right looks like the Three Stooges.
The Three Stooges on it. That's like a classic copyright case.
Yeah, well, that would have been a little hard to explain, I think. The Three Stooges is what's inside Pandora's box. So anyway, I went with the one on the bottom, second over from the left. So I made a selection, right? I made a selection from a number of alternatives. It could have been 100. I could have run this for, like I said, an hour trying to get the right one. Would that selection from a number of alternatives be enough? This is not a question that copyright law provides a whole lot of guidance on at the moment. I mean, there is some case law suggesting, selection coordination and arrangement is one of the things you can do to get to add creativity to a compilation. There aren't a whole lot of cases just involving selection where the work itself is created from the selection, right? Some sort of expressive work, right? You're expressing some sort of message, and you're doing it by selecting from a number of options. We have cases sort of suggesting, selection can be creativity. We don't really have cases on that because our previous, series of cases come from humans creating the entire work. Maybe selections are a part of it. It's not the entire thing the human is doing. So this is I think it's a fiendishly difficult issue that will put a lot of pressure on copyright's minimal creativity threshold. So anyway, that's the third disruption. The third of the 3 spirits leaving. So what about the fourth one, my bonus one, right? The unexpected fourth spirit. What's my hope for artificially created work? So I'm willing to trade all of the evils of the 3 spirits I just had up on the slides in return for my hope. My hope is that artificially intelligent programs will finally give us Half-Life 3.
understand. I am supposed to do. Is that right? I want to.
Yes, please.
Yeah. Okay. I want to tear into this argument. Damn it. All right. Well, first of all, thanks a lot because you said you weren't going to be funny and you went and did it anyway. I thought that I would say, number one, the history of copyright law has been a history of disruptions. And again, as I tell my students, there's no crying in copyright, right? Stuff gets disrupted, business models evolve. Just get with the program. This is a capitalist system here, folks. At least in this country. Next, I wanna hand it off to ChatGPT. I wanna say, of course, I've spent a lot of time with these AIs over the past few weeks and months preparing lots of images like those and a lot of snippets, a lot of asking it how it would rewrite Star Athletica because it's part fantasy. There was candlelight. It was just between us. It was nice. It was a nice moment. But one of the things I want to say that I appreciate about the essential sort of human forward traits of this AI is one, no sooner had it started saying things to me that it was mansplaining. So that's number one. Sorry, I have to say it. But number two, it was very clear that it had an axe to grind. So I asked it basically who was the better author, AI or monkeys under copyright, because I was just curious what it knew, what it was going to say. And so here's, it was fairly equitable. I just want to share some of the thoughts that it relayed. So first, it is important to note that copyright law protects original works of authorship regardless of the author's species or origin. The Copyright Act, you know what I'm saying about the mansplaining a little bit? No? Okay, the Copyright Act, it's copyright splaining. Let me back up. This is not a gender-friendly argument. Okay. The Copyright Act of 1976 states that copyright protection is available to original works of authorship fixed in any tangible medium expression. Now, this is ChatGPT telling us this language does not specify that the author must be human or have any specific origin, making it clear that non-human authors, including AI systems, could qualify for copyright protection if they meet the requirements of originality and fixation. Furthermore, AI systems like GPT-3 demonstrate originality in their output. Moreover, granting copyright protection to AI systems like GPT-3 would serve a compelling public policy interest. So my next question for it was, ChatGPT, what compelling public policy interest would be served? Now, it wrote me such a long essay in response that I want to say a little bit like, gosh, you're so good at rent seeking. Welcome to copyright. Right? How could that be anything less than the true spirit of copyright? If you want a copy of what it said, I can share it with you, but I want to end on that note. So thanks again.
I think we got time for just a couple of questions. I don't want to keep everyone from dinner too much. Anybody ChatGPT out there? Any comments for our evil twins? Oh, in the back, Justin.
So you all know that ChatGPT's works are protected under UK copyright.
Yes, in New Zealand, right?
Since 1988, in the UK, computer-generated works have been protected. So we have several jurisdictions where it already has copyright.
Absolutely, it's doable.
Yeah.
They do. Anyone else? Mark.
So first, I just want to say that I would trade Half-Life 3 for a rewrite of Star Athletica.
Yes. Really?
That's a high price.
We might have some selection effect in the room. That's kind of what?
So my actual question. I took a look at the definition of works made for hire, and I can't actually find a reference to a person. There may be a way in which context could be read to imply it, because it has to be an agreement. But I wonder whether sort of since we already have a category of things that are automatically, when generated, owned by a non-human entity, whether the subset of works made for hire could fit into the ownership category.
I think that's a great idea, but I had it 10 years after Anne Marie Bridey had it. So her work on this is excellent. And no, and I wasn't trying to be harsh to you. I was just saying, I think that's a great possibility. Although she works through in her article, Coding Creativity, what would be needed to implement something like that. But what does she know about like tech? But I like that possible solution, right? We could make some decisions, and we could, per what you just said, Justin, we could also take the approach of
UK law.
right. No, pardon.
We could copy UK law.
We could copy one of the jurisdictions that does permit protection, but does something specific with it, right? Diverts it to something, one way or another. Whether it's work for hire or something else.
Yeah, I think giving protection when under UK law, or like applying like a work made for hire doctrine to what a computer does at the bidding of a human, when the human's not that specific about what's supposed to happen. I think that's a bad outcome for the reasons I was saying. Even if it's technically possible under work made for hire doctrine, I still think it's overprotecting. It's extending copyright unnecessarily to something that really I think would best serve the public interest by just being free and available to use. Of course, if you're not going to do that though, then the problem immediately becomes, how do you draw that line? But despite not taking a position on that, I'm going to take the position on that. I'd rather engage in line drawing than have a flat, clear rule that's overprotecting.
Great. One last question. Here we go.
Isn't this line drawing exercise one of the myriad of uncomfortable line drawing exercises that copyright demands of us, pretty easily resolved by one of the other difficult line drawing exercises we have to do, which is the idea expression dichotomy? Don't we just ask, did the human submit an idea or create an expression, and then we're done, right? It's just easy.
Well, the good news about that is that it is a really clear test. The longer version of my thoughts on this outside of the debate really are like, I think we would do well to drop stuff potentially into copyright. I never say this in any other context, by the way, but to really focus on limiting doctrines, because my worry is that generative AI like this are going to produce tons and tons of things that are incredibly similar and dump a lot more into protection and bloat the scope of protection. And that's one of the reasons I'm sort of willing to concede on this a little bit. That and all the principled and very funny things I said earlier.
Right. There's a lot of hard tests in copyright. It's an interesting question whether this is like marginally harder than all the other hard questions that we have. Perhaps not, but it definitely adds to the load. So that was a way of waffling without giving you an answer.
Well, great. Thank you so much. So they can remember that they're evil, and they can put something in their office where people will say, "What the hell is that?" Thank you all both. Dinner.